Education, which oversees the We the People program for that state. Your judges are here. They will introduce themselves. They will ask you to introduce yourselves, followed by the reading of the question, and then the hearing as normal. And there'll be time cards at the appropriate times, I hope, in this box.
Okay, welcome, Virginia, to day 3 of the national finals. I remember you. I wasn't on 3 yesterday. I was on 6, but I do remember you from 6. So I'm looking forward to a great conversation. My name is Tom Vance. I'm a professor, still a professor of education at Kansas State University. And my colleagues are?
I'm Rita McCannon. I'm an attorney from Huntsville, Alabama.
My name is Darcy Kern. I'm a professor of history at Southern Connecticut State University.
And would you all please introduce yourselves to us?
Hi, we are from Maggie L. Walker Governor School in Richmond, Virginia, and my name is Ananya Shah.
My name is Elizabeth Celentano.
And my name is Amanda Perez, and our coach is Mr. Olmschneider.
Well, fantastic and welcome. Thank you a lot, Mr. Olmschneider, for bringing your students and providing them with this awesome experience. Here are a few questions that will frame our discussion today. We're doing question number 1 from Unit 3. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states, said Oliver Wendell Holmes Jr. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please, whatever you do, for Pete's sakes, support your position. What limits, if any, would you place on the practice of judicial review? You may begin when you're ready.
Alexander Bickel wrote, when the Supreme Court declares unconstitutional a legislative act of an executive, it thwarts the will of representatives of the people and it exercises control against the prevailing majority. However, the court rarely acts as Bickel feared. As a weaker institution, many of its high-profile rulings follow public opinion. In his critique, Bickel was responding to Brown v. Board, a decision which led to severe backlash against the court. The backlash, though harmful to the court's public legitimacy, did not represent a national majority. A 1954 Gallup poll found that while 71% of Southerners disagreed, 54% of Americans supported it. The court made a counter-majoritarian decision by contradicting the Arkansas legislature, but it followed national opinion. Similarly, in 2015, the court followed public opinion on same-sex marriage. At the time of Obergefell v. Hodges, the Pew Research Center found 57% of Americans supported same-sex marriage, a dramatic change from 2010 when only 42% supported it.
However, the court often allows unconstitutional limitations upon minority rights when acting majoritarian. In 1951, the court effectively banned Communist and Socialist Party speech in Dennis v. U.S., following rising anti-communist sentiment. When the court does act counter-majoritarian, it often defends the constitutional freedoms of disliked minorities from local majorities. For example, in Engel v. Vitale, the court invalidated state-sanctioned school prayers, reaffirming First Amendment rights against establishment of religion. The court even protected KKK speech in Brandenburg v. Ohio.
The Federalists would have agreed with Holmes and disagreed with Bickel. As Hamilton wrote in Federalist 80, 13 independent courts of final jurisdiction over the same issues is a hydra in government for which nothing but confusion can proceed. Judicial review has impacted federalism by intermittently expanding national government power. Article 3, Section 2 specifies when the Supreme Court has original and appellate jurisdiction. In Fletcher v. Peck, the Supreme Court used judicial review to declare a state law unconstitutional under the Supremacy Clause for the first over 950 times.
Cases involving the Commerce Clause exemplify how judicial review expands federal power, especially congressional authority. The court revolutionized the Commerce Clause by upholding the constitutionality of the Agricultural Adjustment Act in Wicker v. Filburn. The court approved congressional regulation because many farmers producing excess wheat for private use would substantially impact interstate commerce. Wicker set a precedent for a broad understanding of federal regulatory power post-New Deal, like in Garcia v. San Antonio MTA, where the court ruled the Commerce Clause gave Congress power to require state and local governments pay employees minimum wage.
Also, the Chevron deference established in Chevron v. Natural Resources Defense Council impacts federalism. The Chevron deference means courts defer to the interpretation of the statute made by the government agency enforcing it unless it is unreasonable. This use of judicial review to evaluate the meaning of federal laws and not just constitutionality has further limited state power. Likewise, incorporation has narrowed state sovereignty. For example, in Robinson v. California, incorporation of the Eighth Amendment nullified a California law criminalizing narcotics addiction. The court's pattern of favoring federal power has exceptions. The court ruled in U.S. v. Lopez, the Gun-Free School Zones Act exceeded Congress's Commerce Clause powers. Justice Frankfurter said in Terminiello v. City of Chicago that jurists do not dispense justice according to individual expediency. Most limits on the court are self-imposed, like the strict necessity doctrine and stare decisis.
Imposing limits on the composition of the court to restrict judicial review would inherently impact rulings. Staggered 18-year term limits could ensure that no president has too many appointments and lower the partisan stakes of hearings. Similarly, a bicameral confirmation process rather than unicameral might create more bipartisan support for justices, given our 1970s trend of divided government. This would also make the process less counter-majoritarian, as the House proportionately represents a national majority. The process would be less politicized and decrease problematic decision-making on the court itself.
Thank you very much. We have some questions, however, and maybe I'll begin. You seem to assert that the Supreme Court has tipped intermittently the balance of power towards the national government or the central government vis-a-vis the states. On the whole, has that been a good thing, or can you provide any examples when that's been such a not a good thing?
I would certainly argue that on the whole, this has been a good thing. And I would say that because when the court started to expand federal power in the 1930s during the New Deal, it was focused on providing minimum federal regulations for labor and food and drug use. And these minimum restrictions do provide an additional layer of safety to all Americans. And these layers of regulations now apply to everything from cars to consumer protection.
I would actually disagree with my colleague. I think that it inherently hinders, to a certain extent, the laboratories of democracy idea that we see with states being able to experiment with different things. For example, when the Supreme Court did not incorporated the Second Amendment, it actually prevented states to be able to experiment in regards to gun control legislation in order to see what different kinds of legislation could happen, and inherently hurt a little bit the ability for different types of legislation to be experimented with.
Excellent. One quick follow-up. Can you derive any principles from your understanding of judicial interpretation and federalism? What principles might guide the Supreme Court in ruling about national power versus state power? Are there any things, any principles that where the court should say, yeah, these kinds of things are definitely national in scope, and these things should be left to those laboratories of democracy, as you said?
So in terms of principles, Justice Breyer has actually articulated these 6 tools that are the justices commonly use in interpreting cases. And I think one of them that is really important is consequence. So when looking at how the consequence of the ruling will affect public opinion and affect the public legitimacy, it's in the best interest of the court to favor national or state power in that regard.
Furthermore, some recent commerce clause cases like U.S. v. Morrison have broadly argued that a lot of interstate commerce that Congress uses actually isn't really interstate commerce. For example, this is about the Violence Against Women Act, and they actually have articulated in some recent cases that it is that some of that power needs to be returned to the states, that the Congress cannot just use the Commerce Clause power as sort of a catch-all to validate all of their legislation under the Constitution.
Furthermore, to go off my colleague Elizabeth's statement, I think that one thing that really showcases this doctrine of consequentialism is the political question doctrine that the court uses when dealing with issues of, for example, foreign policy. In one case, Goldwater v. Carter, several Republican senators sued Democratic President Carter when he tried to unilaterally leave the Sino-American Treaty. However, the court decided that this was a political question to be decided between Congress's Article 1, Section 8 power to to resolve treaties for the president and to advise and consent to them as well, which is also a power in Article 2, Section 2.
Thank you.
Switch gears on you just a minute. One of you mentioned in your opening statement the confirmation process and the fact that it could be modified and possibly adjust the tenor of the court. Would you propose or agree with a change? And the ones that you mentioned, do you agree or disagree with the things about which you spoke, about changing the confirmation process from the way it is now to a bicameral consideration?
Yes, I definitely agree with the point of our paper. I think in regards to the bicameral confirmation process, it's really important as the Supreme Court gives rulings impact all Americans, but the Senate is not a proportional representation of all Americans. And so they need to be included in the confirmation process. We have this basis also in comparative. So actually Germany, their system, their final constitutional court actually is appointed by the Bundestag and the Bundesrat, both of which are proportional representation chambers in their legislature. So it certainly has precedent and would be broadly more impactful and also properly represent all Americans.
I would also argue that the staggered 18-year term limits we suggest would help to combat the issue that we've seen in recent years. For example, many would say that it's not quite fair that President Trump had several Supreme Court appointments while President Bush only had 2, with 8 years versus 4 years. So having a staggered 18-year term limit to modify when justices retire and to allow spacing between them would make sure that presidents all have equal opportunity in appointing justices, which would also hopefully combat the partisan imbalance on the court.
I actually disagree with our bicameral confirmation process proposal. I understand the reasoning for making the process as a whole more representative. However, I do feel that including the House in the Article 2, Section 2 confirmation process would cause for confirmation hearings to become more of a spectacle, in that the House is more diverse and largely has more extreme partisan views within the representatives. So I do think the confirmation process being a spectacle has been an issue recently that people have talked about. So I think that would contribute.
You guys have mentioned the Commerce Clause several times, and the Commerce Clause has been at the heart of many of the most important Supreme Court cases in the last 25 years. And its application has changed from Rehnquist to the Roberts Court. Could you talk more about the use of the Commerce Clause?
Sure. So the Commerce Clause broadly was restricted on the federal government's powers under the Lochner era, which broadly did not allow for a lot of labor rights, as well as a lot of initially the New Deal legislation that FDR was proposing. And then we eventually saw a shift in that, which I'm sure my colleagues will discuss.
So broadly, after the New Deal, the Commerce Clause was used to justify not only minimum standards for regulation, such as with the Food and Drug Administration, but in the consumer protection era in the 70s and 80s, it was used to justify congressional regulation of labeling and to protect against the false advertising of consumer products, such as everything from household products to cleaners and everything in between.
Importantly, from this era, from 1937 to 1995 with US v. Lopez, and the court did not strike down a single congressional act under the Commerce Clause. And I think largely that is due to this changing perception of the federal government's place in protecting individual rights through regulations that Commerce was enacting, especially with the civil rights movement and the use of 14th Amendment protections, which have been used to with the Commerce Clause to regulate interstate rights.
There's nothing in the Constitution that says the Supreme Court should have the power to declare an act of Congress or a co-equal branch unconstitutional. At least it's not explicit. Did the founders intend for the court to have this power? And what evidence can you provide, either in terms of the Constitution or in terms of your historical knowledge, that it was intended by the founders?
Absolutely. It definitely was intended by the founders. In the Constitutional Convention, part of the Virginia plan was actually a council of revision that would be part of like a legislative branch to review the acts of the legislature. And this was actually not passed and in favor of an independent judiciary, because the founders understood that it would be the peculiar province of the judiciary, to use Chief Justice Marshall's terms, to review those laws.
Furthermore, we can see that in Federalist 78, Hamilton specifically warns, advocates for the life tenure and the regulated salaries of justices to
Right.
insulate them for political
Okay.
processes.
Real quick, we're running out of time. Any precedents then before 1803 and Marbury versus Madison that you can point to, say, yeah, there's judicial review there. You can see it here. There it is. Any before 1803?
Certainly. In English common law, William Blackstone actually implied in his writing that when people are given rights broadly, that there needs to be some institution that can actually affirm them.
Thank you very much. Excellent performance, Virginia. That I pushed you a little bit there, and you rose to the challenge. Yeah, the last question there, by the way, that historians still, there's some historians, they're in the minority, but they still say, why didn't they just come, if they really meant it, why didn't they just come out and say that, you know? And so the supremacy clause can be interpreted a number of ways, as you know, and Marbury chose a particular way to interpret it, but it could mean too, just that the Constitution, the laws made after the Constitution and treaties made before and after the Constitution were all supreme law of the land compared to state governments, not necessarily compared to co-equal branches. So it's an interesting question. One small thing, I ask you to derive principles in terms of the Supreme Court deciding the division of power between the federal and state government. Difficult question, especially to think of that on your feet. But having that skill is nonetheless unbelievably important. So you could have talked about the rights of minorities, the rights in the Bill of Rights, things that need to be nationalized are properly in. The court should look at those in terms of national power. Overall, excellent job.
You guys answered my question. You didn't have any problem with it. You had done enough detailed research. I would venture to say, Elizabeth, that the show that you were talking about, them putting on in a confirmation process would happen if they were having it at the Starbucks. It wouldn't matter if it were the House of Representatives or the Senate or anywhere else. But I understand what you're saying, trying to corral it in one chamber and not take it all over the place. But I thought y'all did a wonderful job, and you didn't seem taken aback at all by these professors' really tough questions.
That was very good. The second half of your introductory statement was excellent. It was very specific in application to the questions. I thought your answer to the first follow-up question, where you talked about minimum regulations for labor, and then I think, Amanda, you came in with the laboratories for democracy. That was excellent. And then when you came in at the end with Blackstone and common law, I mean, way to handle that. That was great. I do think that you could have spoken more on my question about the Commerce Clause. I think you could have spoken more about the Roberts Court and using it for healthcare and education. But yeah, I mean, that's a minor critique because this is such a high level of competition. You guys are very, very good.
Thank you so much.
One quick thing, in terms of precedents, there's also, and your teacher probably knows this one, Hilton, what Hylton, which they didn't declare an act unconstitutional, but they reviewed it right in 1797 or something like that.
The carriage tax case.
That's it. And then there were a few in colonial America too that you could point to. Just those are small, technical points. Excellent job.
Thank you so much for taking your time to judge us today.